Senator Rennick.
Thank you, Acting Madam Deputy President. And I rise to speak in favour of this motion. This is a House of Review. The Senate is a House of Review. We've had numerous speakers tonight to say that the Native Title Act isn't perfect. So why can't we have an inquiry into it? Don't let perfection be the enemy of good. So let's have a look into it. And I think we need to ask ourselves what is the problem here. Personally, I've always had an issue with native title because it's got no inbuilt redundancy. Are we still going to be talking about native title in 100 years, 200 years, or will this Native Title Act finally be put to bed? Because while I concur with the original Mabo decision that if you could prove continuous association with the land, that the traditional owners are entitled to that land, I have a problem with the continual claims over unused council land or unused state land. I pay taxes. My constituents, fellow working Australians also pay taxes. To say that they already don't have a claim over this land is ridiculous. The idea, for example, that there's parts of Redland Shire, the Waverton Bowls Club, and my old hunting ground stomping ground in Sydney, has been basically given up to native title. So there's no continuous association with land for a very long time. The North Sydney Council used that particular bowling club as a bowling club. It was there for all the people of North Sydney and other people in Sydney whoever may attend. So the idea that we can now go and rewrite laws and then say that this, you've got title over this or title over that, when will it end? When will it end? I mean, we are one country, and the fact that we've got different laws for different races is actually a convention of the International Convention. Goes against the International Convention on the Elimination of all forms of racial discrimination. Now, I don't usually like to rely on foreign treaties to get my point across here, but the fact is Article 1.4 says special measures, and this also applies to the voice, mind you, which also has no inbuilt redundancy. Once it's in the Constitution, it will be there forever as well. And quite frankly, I think if the Native Title Act doesn't actually have a sunset clause, it also falls into a breach of the International Convention on Elimination of all forms of racial discrimination. And I'll read out point 4, which says special measures taken for the sole purpose of securing adequate advancement of certain racial or ethnic groups or individuals requiring such protection as may be necessary in order to ensure such groups or individuals enjoy equal enjoyment or exercise of human rights and fundamental freedoms shall not be deemed racial discrimination, provided, however, that such measures do not, as a consequence, lead to the maintenance of separate rights for different racial groups, and they shall not be continued after the objectives for which they were taken to have been achieved. In other words, you cannot continue to have affirmative action or any other action once that standard of living has been improved. So at what point here, and I just want to raise this again, get the 1992 decision, the Mabo decision. That High Court decision was sound, even though I must admit it was a close contest. It was 4-3 between the High Court judges, but it's reasonable, continuous grounds. And yet that particular condition of the original Mabo decision has been watered down over the years now, where we are getting claims over a large part of Australia, and this actually isn't doing anything to help the Aboriginal people at all. The only people this is helping are the lawyers, because this is a lawyers' picnic for claims against the federal government, or the state government for that matter, or local councils. So, of course, the lawyers are basically fleecing the pockets of taxpayers here. And as usual, they use virtue signalling to justify their extortion, but that's what we are looking at here. So I think there does need to be an inquiry into this. I think it's time we called out the rorts, and we also need to have a look at a section of the Tax Act, Section 59, I think 15 and 50, where land councils don't actually have to pay income tax on royalties and native title payments. Now, yet again, this cuts both ways. I mean, we always hear in this chamber how the Aboriginals were dispossessed of their land and that they've somehow been discriminated against, but there's also been benefits brought into this country as well. So I don't see why these measures have to continue indefinitely. Now, there can be an argument whether we can wrap it up by 2025, but let's have the inquiry and let's investigate that. But to say that it's not workable or there's one thing wrong, so therefore we won't have the inquiry, I totally disagree with. We've seen too much of this under the Albanese government, not enough transparency, not enough scrutiny and not enough accountability. I mean, the whole point of the Senate is a House of review. I mean, the Mabo, the Native Title Act now is 30 years old. I think it's due for a revision. You have to ask yourself, when they introduced the Native Title Act back, I think it was in 1993, 94, was it? 92, whenever, was this the intended result? That today, 30 years on, we've got claims over various parts of Australia that are only going to get tied up in the courts indefinitely. So, a lawyer's picnic, various bureaucratic agencies will be involved in dealing with these native title disputes. And of course, the problem with that is these people aren't working on the front end where they're providing services to the regions where people do need help and where you can actually work on closing the gap. So I'll leave it at that. Thank you.
Authorised G. Rennick, LNP Chermside.